Hi everyone, I am Meenakshi and I welcome you all to Tathastu. And as you can see, today we are going to discuss a very interesting and another important topic for a UPSC examination, which is about the President Rule. Now, President Rule is again in news. Why? Because Punjab Governor has warned Punjab CM that he would impose President Rule in the state because of such. And in this video, we are going to see on what grounds can President imposed, on what grounds can it be revoked, what are the proper use and misuse of this President Rule, and how many times this rule have been imposed in India. But before moving on, let's see these courses which are offered by Tathastu-ICS for all of you. The first is MSLV, that is Main Success Launch Vehicle. Admissions are open for this program. You can get enrolled in this. Then the NCRT module also available for it. PSLV, which will be coming very soon for prelims examination, and philosophy optional by Tanu Ma'am is also available. You can get yourself enrolled if your optional is philosophy. Now let's begin with the lecture about the President Rule. So first of all, we'll see the articles under which President Rule can be imposed. There are two articles, two reasons under which this rule can be imposed. And one of the reasons is Article 356 and other is basically you can easily remember 3, 5, 6, 5. These are the two articles under which the grounds of President Rule are mentioned, and these articles allow the President. Okay, we are talking about Article 365 particularly. Article 365 allow the President. Article broadly this article about your President Rule. So first we will what is mentioned in Article 356. Now it gives the President of India authority to dismiss a state government if it believes that the governance in that state cannot be carried out in accordance with the provisions of the Constitution. So when we talk about Article 356 broadly, here the President declares the President Rule, or the President Rule is imposed in the state on the recommendation, on the report of a governor, and if the President found that yes, the conditions are not conducive, the machinery is not the constitutional machinery, the administrative machinery actually is not being carried out in accordance with the provisions of the Constitution, then President Rule can be imposed in that particular state under Article 356. Here we are talking about Article 356. And this article is basically invoked when there is a breakdown of constitutional machinery, and if the governor thinks that the state government is not carrying out the administration according to the provisions of the Constitution, then it can the governor can submit a report to the President to impose President Rule in that state. I hope it is clear what Article 356 says, and under this it is often referred as President. Now President can take this action based on a report of governor, as I say, of the concerned state or other information. If he sees, even if the President realizes that the constitutional machinery, the administration is not being carried out with the provisions of the Constitution, then also the President can impose the President Rule in that state. So that was about Article 356. Now this is Article 365. It empowers the President to issue a proclamation if a state fails to comply with the directives which are given by the central government. Now, when we talked about 356, it was about governor. So 356 talks about if the governor of that state thinks that the state government is not following the provisions of the Constitution, he may submit a report. Whereas in this article, if it says a center gives any direction to a state government and state government refuses to comply with that direction, that we are not, suppose the center says that this law should be enacted in your state, and the state government denies straightforward that we are not going to implement this law, then President Rule can be imposed in that state. So this is under Article 365, that if a direction is given by the center to the state government and they fails to comply with it, then the President Rule is imposed in that state under Article 3. So I hope the difference between Article 356 and 365 is clear. Now, if a state refuses, this is the broad definition which we have already discussed. If a state refuses to follow or implement a directive from the central government, if a direction, if an order is given by the central government and the state government refuses to comply with it, so president rule can be imposed under Article 365. The president can conclude that a situation has arisen in which the government of the state cannot be carried in accordance with the provisions of the constitution, and thus he or she can impose the president. So this can lead to president rule. States. We have discussed it broadly, and I hope the difference between Article 356 and 365 is clear to you. Now, this is also known as, there are other names as well, it is also known as state emergency or constitutional assembly. President rule is also known as state emergency or constitutional emergency. Now, there wouldn't be any council of ministers. So we see the chief minister. How does our government functions? At national level, we have a council of ministers which is headed by the prime minister, and state level, same, we have a council of the chief minister of that particular state. So, but if this president rules is imposed in that state, there would not be any council of ministers after this will be put into place. Now, the governor will continue to oversee the affairs as the president of India's representative. So, the governor submitted its reports, so he becomes the representative of president of India, and he oversees the affairs of that particular state. And the state would come under direct administration of the union government or the central government. The effects of president rule as well, but this is just a broad overview that it is known as state emergency, no council of minister after that. Governor would see all the affairs of that state, and the state would be under direct control or direct administration or central government or our union government. Now, moving on, parliamentary approval and the duration under which that order which have been imposed, that should be approved. Moving on, within 2 months. So the duration under which that order should be improved, that notification which have imposed the president rule in a state. So the duration for that is 2 months after the date of issuance. A proclamation imposing president rule must be ratified, and it must be ratified by both the houses of parliament, that plus. So the approval of both the houses of parliament is required for this president rules. And if we talk about majority, it is simple majority is required. So in either house, the approval is granted by a simple majority. So these are the basic facts which can be asked in your prelims examination. The kind of majority for approving a president rule is simple majority, as we have seen, and the duration under within which this proclamation should be approved is within 2 months after the date of issuance and with simple majority. Now, with the consent of parliament, the president rule, here we are talking about extension. So with the consent of parliament, it may be extended every 6 months. Every 6 months, there can be a fresh notification stating that this state would be under president rule only, but the maximum period is 3 years. That means beyond that 3 years, the parliament or the president cannot enforce president rule in that state. The election should be conducted over there. So this is the duration within which the proclamation should be approved, and with the majority, simple majority, and it can be extended 6 months at a time. So after 6 months, the president may issue a fresh notification, but the maximum period for a president rule is 3 years. If ever it is asked in your examination, the maximum period, always remember, it is 3 years. Beyond 3 years, the president rule cannot be extended in any state. Now, what happens is a condition during this period. We have this 2 months period time for the approval, as we have seen. With 2 months, the proclamation should be approved. But what if they have given a situation, what if the Lok Sabha is dissolved within that particular period? So if the Lok Sabha is dissolved during these 2 months, and then meanwhile the Rajya Sabha approves that proclamation. So here we are considering that Rajya Sabha has approved that proclamation, but Lok Sabha is dissolved. Now what will happen, because we have seen that majority, simple majority and approval of both the houses is required for the this proclamation. The proclamation will become ineffective after 30. So in the meanwhile, when this Rajya Sabha has approved this proclamation, and after some time there is a newly constituted Lok Sabha. So after its first sitting, within 30 days, the Lok Sabha must approve the proclamation which have been issued, and given that the Rajya Sabha has already approved that, I hope it is clear that if the Lok Sabha is dissolved during that time, and during these 2 months time, and Rajya Sabha is approved, and after the first sitting of newly constituted Lok Sabha, within 30 days that proclamation should be approved by Lok Sabha, otherwise it would become ineffective or it would cease to operate. This is the condition if the Lok Sabha is dissolved. Now moving on towards the revocation. Till now we have seen how it is approved and what majority is required for the approval of that proclamation. Now moving towards the revocation, the president may at any moment revoke a president rule proclamation, and for that he just have to give a new proclamation. No parliamentary approval is required for its revocation. Now you see the difference. For approval you require parliament approval, you require Parliament's approval, Lok Sabha plus Rajya Sabha. But for revocation, you don't need any parliamentary approval. I hope it is clear to you. The president may revoke that proclamation with a subsequent or a new proclamation that the president rule has ceased to operate in this particular state in which it was imposed. Now, is it subject to judicial review? We are talking about president. So is president rule subject to judicial review? Can it be challenged into court? So before till 38th Amendment Act of 1975, the president approval to use Article 350 came conflict. So a 38th Amendment, when 38th Amendment Act was said that president's decision is final, his satisfaction is final and conclusive, and his decision cannot be challenged into court on any ground. So 38th Amendment Act make this presidential rule immune from the judicial review. But this provision was later deleted by the 44th Amendment Act, which came in 1978, and said that this president rule, the president's satisfaction, is subject to judicial scrutiny. That means that decision can be challenged into court. So if a question comes, is president rule subject to judicial review? Yes, it is subject to judicial review. And by which Amendment Act it was made possible? It was made possible by 44th Amendment Act. Otherwise, 38th Amendment Act made the president immune from this judicial review. Now moving on, what are the effects of this president rule? President rule is imposed in a particular state. What are the effects on that particular state? We will be discussing all this. These are very important, specifically from your prelims point of view, because many questions have been asked on this particular topic. So this emergency provision particular topic is really important for it. So let's discuss what are the effects of this rule or this proclamation. All or any of the state governments may be assumed by the president, or they may be delegated to the governor or any executive power as the president considers it. The state assembly may be suspended or dissolved. So you have to remember these. The state assembly can be suspended, the president can suspend it for a certain period of time, or the president can dissolve it. Things it is necessary to dissolve that assembly. Both things can happen. So always remember, it can be suspended or it can be dissolved by the president. Now he may give Parliament the power. We have seen the Parliament assumes the power for the administrative function in that particular state. So the power may be given to the Parliament to enact laws on state legislation. Parliament make laws on these central subjects. The state list, the subjects which are mentioned in the state list, the laws are being made by our state government. But if president rule is imposed in a state, the Parliament may assume that administrative power to make rules on that particular subject or to make laws on that particular subject. Now, any further incidental or consequential provisions required to carry out the proclamation purpose may be made by the. So apart from all this, if the president thinks that there are other provisions, there are any other provisions which are required, then also he can delve those power, dilute those power to any particular authority as he may seem, as it seems necessary. Now the president is not permitted to take over the high courts. All the powers of the state legislature lies with the Parliament for specifically for administrative purpose. But the judiciary powers cannot be taken over by any. The power of that particular state high court cannot be taken over by our president. And if we talk about fundamental rights, so fundamental rights are unaffected. Fundamental rights are affected during the national emergency time, not during this president rule. So these are the effects of president rule. Now moving on. Uses and misuse of Article 356, in which case it can be used or in which cases can be misused. Here we are talking about uses, the fair means, how a president rule can be used through fair means. So if the result of the assembly election is hung assembly, if no party has a clear majority and there is a hung assembly, then president rule can be imposed. It is legal, it is valid. If the majority party declines to form a government, but that is a very rare incident that any party has gotten majority and that declines to form a government, but if it happens, then this president rule can be imposed. Third is no party is willing or able to form a government. Now, even if a party has majority, we have seen it, and they just decline that we don't want to form a government, or any other party doesn't come forward that we want to form a government, president can be imposed. Fourth is if there has been non-compliance by the state with the directions issued by the union, and we have seen this happens under Article 365. If any directive is given by the center and the state doesn't comply with them, then president rule can be imposed. 365. Now, internal subversion is a government deliberately acting against law. So if a state government deliberately act against a law or in ultra virus of the constitution, then president rule can be imposed. And if there is a physical breakdown of the machinery, to say the government willfully refuses to discharge its duty, then the president rule can be. Now moving on, improper use. If we talk about the improper use, so first is without a floor test purely based on the assessment of the government. So if here we have seen, can understand it with example. If the majority party declines or no party is willing, if the result of the assembly is hung assembly, but apart from this, if a party says that they want to form a government, and then the governor of that state doesn't consider that decision, or without conducting a floor test, he just sends a report to the president that there is no party is willing to form a government, so president must be imposed this state. So number one is this is a improper use of this article. Now the government falls, but the governor does not explore alternative possibilities. If he doesn't ask any other party that whether they want to form a government or not, then also this is improper use of this particular article. Now, nearly on the ground of maladministration, allegations, corruptions, or financial exigencies, and the governor doesn't warn the state government, and for example, we have seen that Punjab governor has warned the state chief minister once that the president rule will be imposed if certain conditions are not met. So if the governor doesn't warn and just straight away sends the report to the president, then this is a improper use, and without giving a prior warning for rectification to that. These four are the cases of improper misuse. Now this is the stat of how many times this president rule has been imposed in India. You can take a screenshot of it. This data is up to 20. So you can see maximum number of times. If we see this graph, maximum number of times it has been imposed in Jammu and Kashmir. And if we talk about when was president rule first imposed, it was firstly imposed in 1951 in the state of Punjab. First, talk about in which year it was imposed. So it was first imposed in 1951 in the state of Punjab. Apart from that, the stats till now, till 2020 actually, and Jammu and Kashmir is so far seen the maximum imposition of this particular article 3 of president. Now, SR Bommai versus Union of India. This was a landmark judgment with respect to the president rule. He is SR Bommai and he was the chief minister of Karnataka at that time. So and his government was actually dismissed, and without considering that whether his government lost majority, and the governor without considering whether they want, without considering the floor test, the possibility of floor test, just dismiss their government and send a report to the president stating that the president rule should be imposed over here. So he went to the court, and here are the decisions which was given by the court. So by laying forth restriction, the Supreme Court, it was a historic order with respect to the president order, and it put an end to arbitrary removal of state administration, specific Article 356. Here we are talking about Article 356, and this verdict concluded that the power of the president to dismiss a state government is not absolute, and we have also seen that it is subject to judicial review now because of after 44th Amendment Act. So the verdict concluded that power of the president is not absolute to dismiss a state government. It is subject to the judicial review. Now, according to this ruling, the president shouldn't use his or her authority before both the houses of the parliament have approved the proclamation. So we have seen for approval we require, for this proclamation approval we require the majority, simple majority of both the houses, and the approval of both the houses, Lok Sabha plus Rajya Sabha, through simple majority. And the president can only suspend the legislative assembly once the constitutional provisions governing this legislative assembly are. So these were the points or the judgment that was given in this particular case. So if a question comes, so SR Bommai versus Union of India, to some extent position of president rule. This is a previous year question which has been asked in your question. Let's see it. If the president of India exercises his power under Article 356, but here we are talking about Article 356 of the Constitution in respect of a particular state. So if a president is exercising his powers which he have under Article 56, then we have to see the options. Number A is the assembly of the state is automatically dissolved. Number 2 is the power of the legislature of that state shall be exercisable by or under the authority of the parliament. Number 3 is Article 19 is suspended in that state, it is fundamental right. Number 4 is the president can make laws relating to. So we have discussed all these points in this video. So you have to answer in the comment section what is the correct answer. And I hope you found the session interesting. If you find, please like the video and subscribe to the channel. Thank you.